against Morris and another.
Lady Rose will hand down the judgment.
This appeal concerns an oral agreement made in July 2013 between Foxpace Ltd and Mr Barton about a property in London called Nash House. Foxpace was the owner of Nash House and wanted to sell it. Mr Barton thought he knew someone who might want to buy it. In the High Court there was a dispute as to whether there was an agreement between the parties at all, and if there was, what the terms of the agreement were. The High Court found that Mr Barton and Foxpace had entered into an oral agreement whereby Foxpace would pay Mr Barton a commission of £1.2 million if Nash House was sold for £6.5 million to a purchaser who had been introduced to them by Mr Barton. In August 2013, Mr Barton introduced Western UK Acton Ltd to Foxpace as a potential purchaser of Nash House. Initially, Western was prepared to pay more than £6.5 million for Nash House. However, before the deal was finalised, it came to light that Nash House fell within an area safeguarded for the purpose of the construction of the high-speed rail link HS2. As a result, the purchase price was reduced, and Western bought Nash House for only £6 million. This reduction in the sale price was reached in good faith. That is, it was clear that the reduction was genuinely the result of the HS2 issue. The sale to Western completed, and Mr Barton claimed Foxpace owed him £1.2 million commission. Foxpace refused to pay. Foxpace argued it was not contractually obliged to pay anything to Mr Barton because the contract did not say what was to happen if Nash House was sold for anything less than £6.5 million. Foxpace did offer Mr Barton £400,000 as a goodwill gesture, which he refused. Mr Barton then brought a claim for the reasonable value of his services. His case at that stage was that he had been promised the commission of £1.2 million regardless of the sale price, as long as the sale was to a buyer he had introduced. The judge in the High Court held that Foxpace was not liable to pay anything to Mr Barton. In case he was wrong, the judge assessed a reasonable fee for Mr Barton's services as being £435,000. The Court of Appeal disagreed with the High Court and allowed Mr Barton's appeal. They held he was entitled to a reasonable fee for having made a successful introduction and ordered that he be paid £435,000. Foxpace now appeals to the Supreme Court. The Supreme Court, by a majority, allows the appeal. There are three routes through which this court could hold that Foxpace is contractually bound to pay a fee to Mr Barton for his services. The first is that it was an express term of the contract between them that he should be paid a commission in these circumstances. The second route is that a term should be implied into this particular contract as a matter of fact to give effect to the unexpressed intention of the parties. And the third is that there is a term implied by law as an incident of this kind of contract. As an alternative to his claim in contract, Mr Barton relies on the law of unjust enrichment. That provides a non-contractual route by which one could arrive at the conclusion that Foxpace is obliged to pay a fee to Mr Barton. The majority of the Supreme Court hold that none of these avenues, contractual or non-contractual, leads to the conclusion that Mr Barton should be paid a fee. I shall consider each of these routes in turn. The express terms of the oral contract which the parties agreed were ascertained by the judge from hearing the evidence of the witnesses at the trial which took place before him. He found that it was an express term of the agreement that Foxpace would pay Mr Barton £1.2 million if Nash House was sold for at least £6.5 million to a purchaser introduced by Mr Barton. But there was no express term imposing an obligation on Foxpace to pay Mr Barton a commission if the house was sold for anything less. So what about implying a term? A term can be implied into a contract as a matter of fact if it's needed to give effect to the unexpressed intention of the parties. When assessing whether such a term should be implied, the question the court has to ask is, what the contract, seen as a whole against the relevant background, would reasonably be understood to mean. This question can be expressed through the famous test set out in a case decided in 1926 that a term will only be implied into a contract if, while the parties were making their bargain, an officious bystander suggested an express term to the parties, they would have said, "Oh yes, of course." Another way of expressing the test is that a term will only be implied if it's necessary to give the contract business efficacy. Applying those tests, the majority of the Supreme Court hold that it is not possible to imply a term into this agreement that Mr Barton would be paid a reasonable fee if Nash House was sold for less than £6.5 million. Such a term contradicts the express terms of the agreement. It fails the officious bystander test because it's not possible to say that there's any particular fee to which the parties would clearly have agreed if they had been asked about it. It's certainly not clear that Foxpace would have unhesitatingly agreed to pay Mr Barton a reasonable fee. It also fails the business efficacy test because it's not necessary to imply such a term to give the agreement commercial or practical coherence. A term can also be implied into a contract because the contract is one of a class into which the law implies a term. Section 15 of the Supply of Goods and Services Act 1982 implies a term that the party contracting with the supplier for services will pay a reasonable charge where the payment for the services is not set by the contract. However, the majority hold that this section doesn't help Mr Barton because it doesn't apply in the circumstances of this case. The payment was in fact set by the contract, and possibly also because Mr Barton was not obliged by the contract to provide the service. He wasn't obliged to tell Foxpace that Western might want to buy Nash House. Another route by which the law implies a term is where the term is an incident of the particular kind of contract in issue. For example, previous cases have decided that certain obligations are always to be implied into particular leases or employment contracts, whether or not the relevant party would have agreed to include it. Mr Barton relies on a series of cases in which the courts have in the past implied an entitlement to commission as an incident of the informal contracts commonly entered into between sellers of property and estate agents, so that the estate agent is entitled to a commission when the property is sold to a purchaser introduced by that agent. But the majority hold that Mr Barton cannot rely on the estate agent cases to establish that as a matter of law it is an incident of his contract with Foxpace that he's entitled to a reasonable commission for having made a successful introduction. He can't do so for the following reasons. First, Mr Barton was not an estate agent. This was a one-off contract, and though it was in a commercial setting, Mr Barton was not in the business of making this kind of introduction. Second, the fee of £1.2 million was several times bigger than the reasonable fee for this introduction, which the judge held was £435,000. And third, the fee was not by way of a bonus or related to Mr Barton's costs. It represented the deposits and other expenses that Mr Barton had personally lost on his two previous failed attempts to buy Nash House himself. The majority hold that in entering into the contract, Mr Barton took a risk that if he did not find a buyer at £6.5 million, he would not be able to recover the sums which he had forfeited in the course of those two earlier transactions. Now, turning to the law of unjust enrichment, the issue between the parties is whether Foxpace's enrichment, arising from the introduction by Mr Barton of Western as the purchaser of Nash House, was unjust unless they pay Mr Barton a reasonable fee. The majority hold that an obligation on Foxpace to pay any commission to Mr Barton, even if there was no sale to Western for £6.5 million, is at odds with the terms of the express agreement. The law of unjust enrichment cannot be relied on to circumvent the terms of an existing contract. The benefit to Foxpace of a sale to a purchaser introduced by Mr Barton would not be unjust even if they didn't pay him a reward, because it was an outcome provided for by the agreement. Although this may seem harsh to Mr Barton, unjust enrichment is not a way to improve the bargain that the parties have struck in order to benefit one side of the deal. For reasons which I cannot do justice to in this short summary, Lord Leggatt and Lord Burrows separately dissent. They would both dismiss the appeal. Although their reasoning differs, both hold that the express agreement did not preclude the payment of a reasonable sum to Mr Barton, where Nash House was sold for less than £6.5 million. Accordingly, for all these reasons, by a majority, the Supreme Court hold that the claims in contract and unjust enrichment must fail, and the appeal is allowed.
Thank you. Court is now adjourned.